Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today we are going to discuss a bail petition under section 439 CRPC in which a judicial office assistant has been involved. It happened in Tamil Nadu state. So Justice Anand Venkatesh of Madras High Court, Madurai bench, denied bail in the case of Prakash versus the state represented by Inspector of Police in criminal miscellaneous petition number 11408 by 2022 on 12/5/2022. About a week back, the bail orders they have not been granted. You can see the citation in Live Law 2022 within bracket Madras MAD page number 218. So here what the judge held is more important. So the judge held that it is an attack on the judicial institution. So it has to be, such incident should be dealt with an iron hand and with the utmost seriousness, right? So he has refused to grant bail. In this connection, you all know that bail is a right and jail is only an exception, as stated by late V.R. Krishna Iyer, Honorable Supreme Court Judge, who is a turned politician into a judiciary. Right? But you know that it is the personal discretion of the judge to give bail or not. Normally, according to 436, yes, you can take bail in all bailable offences. Bail is a right. But as regards the non-bailable offence, particularly under 439 CRPC, it gives actually special powers to the High Court and Sessions Court in granting bail. So, to sum up, I want to tell you that bail is the discretionary power. It depends on the discretion of the judge. Here, the incident, if you know, then definitely you will support the judge, right? Here, our friend Mr. Prakash, he is working as an office assistant in the magistrate court, that is 4th JFCM, Salem. He was working as a junior assistant or office assistant in the court of 4th JFCM, Salem, right? This comes under Hastampalli PS of Salem city. It is located in Salem city itself, right? So you may be knowing this is the season of transfers. Academic year is going to a close. Normally transfer orders will be given here. Now this Prakash was transferred to another place for which he was not at all happy. And the other point is he was under the impression that the JFCM, 4th JFCM, he was responsible for the transfer. So after receiving the orders, since he was not satisfied on 1st March, on 1/3/2022, so he went to the chamber of the judicial officer, 4th JSM, while carrying a knife in his pocket and picked up a quarrel with the judicial officer and stabbed him on the ground that he was responsible for the transfer. So immediately the other attender, other staff, they came to the rescue. Of course, luckily he received simple injuries. So he reported the matter to the police station of Hastampalli PS, where they registered a case in crime number or FIR number 98 by 2022 under sections 332, that is obstructing or the discharge of official duties by causing injuries. Then 324, yes, voluntarily causing simple hurt with a deadly weapon, and 307 of the Indian Penal Code. You know what is 307? 307 nothing but an attempt on the life. It is just before, a step below murder. So attempt to commit murder is section 307. Of course, there is no guarantee that there should be a simple grievous injury for 307. Only thing is 2 points they will consider. Whether it is on the vital part or not, whether the weapon used is a deadly weapon or not. Then 307 can also be added. Anyway, so they have completed the investigation. They filed the charge sheet also. He was there in the judicial custody for about, I think 45 days or so. So later, Yes, he has filed a bail petition under section 439 CRPC stating that even though the offence is non-bailable, the investigation has been completed and the charge sheet has been also filed. Right? So Justice Anand Venkatesh, he perused even the wound certificate also, which shows that the judicial officer received simple injuries. No doubt, the advocate on behalf of our friend Mr. Prakash says under section 167 clause 2, he has got a default bail right because for 60 days, if 60 days is completed, he has got a right to get bail. But since already the charge is in bail, definitely he can be let out. But the public prosecutor, he said, Your Honor, it is a very serious case, and if the accused is let out, it gives wrong signal and he may try to threaten the witnesses. Definitely, it will have a serious impact on the institution. Yes, the judge agreed. So that's why I tell you, suppose if a police officer is involved in a case of moral turpitude, then the judge will not accept. He will say, Arey Baba, you are there to maintain law and order, to keep peace in the society. If you do such anti-social activities, definitely you are not allowed to get so-called bail. Likewise, the institution, judicial officer, judicial assistant, no doubt he may have got definitely a grievance. What to do? Then he has to approach the higher authorities, maybe the session judge, maybe the portfolio judge in the high court, and he can represent his grievance. But this is not the way to stab a person. So if you are happy with your posting, it's okay. If you are not happy, then you are going to stab the judicial officer. No doubt, he may be responsible. Let him be responsible. Only two alternatives. Even we also worked in the departments, police department for about 35 years. So I worked. So if you are not happy with the higher officer, better you apply leave or better you get transferred and go away. That's all. You can't pick up a quarrel with him because it is an institution. It is not your personal property. నీకు ఆయన అన్నదమ్ములు తగాదు కదా, ఆస్తి తగాదు కాదు కదా, అధికారం ఉన్నప్పుడు అధికార ప్రకారంగా చేయాలి కానీ యూ షుడ్ నాట్ రిసార్ట్ టు సచ్ థింగ్. Therefore, even though he has approached the High Court has openly stated that the accused was denied bail because it is an effect or serious effect on the institution itself. Of course, the leverage given by the judges, it has asked the Sessions Court to complete the trial of the case within 6 weeks and decide it on merits. That's all. So, very good case regarding bail petition and personal discretion of the justices. 439 CRPs also we discussed. So, please read the judgment and enrich your legal knowledge. Thank you very much.